Welcome to the Pretty Good Policy for Crypto podcast, where we have in-depth discussions on cryptocurrency policy and regulation. My name is Paul Brigner, head of U.S. Policy and Strategic Advocacy for the Electric Coin Company. In a few moments, I will welcome Jennifer Schulp, Director of Financial Regulation Studies at Cato Institute's Center for Money and Financial Alternatives. We believe in fostering an inclusive and respectful environment for our discussions. And while we at Electric Coin Company hold strong opinions about the need for private and confidential financial transactions in crypto to promote economic freedom, our guests may have differing views. Through these thought-provoking and at times challenging conversations, we aim to deepen our understanding of complex policy and regulatory issues and work towards the development of pretty good policy for the cryptocurrency world. This podcast is for educational purposes only and is not legal or financial advice. Our guests' remarks may not reflect the views of their organization or Electric Coin Company. Thank you for tuning in and enjoy the podcast. I'd like to welcome Jennifer Schulp to the PGP for Crypto podcast. Jennifer is the Director of Financial Regulation Studies at Cato Institute's Center for Monetary and Financial Alternatives, where she focuses on the regulation of securities and capital markets. She has testified before Congress multiple times, including before the U.S. Senate Committee on Banking, Housing, and Urban Affairs, the U.S. House Committee on Financial Services, and the Committee on House Administration. Prior to joining Cato, Jennifer was a director in the Department of Enforcement at the Financial Industry Regulatory Authority, Inc., FINRA, where she represented FINRA in investigations and disciplinary proceedings relating to violations of the Federal Securities Laws and self-regulatory organization rules. Before that, Jennifer worked as a lawyer in private practice at Gibson Dunn and Crutcher, LLP, and clerked for Judge E Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. Jennifer received her J.D. from the University of Chicago Law School. She holds an A.B. in political science from the University of Chicago. It's an honor to have Jennifer Schulp on our podcast today, and I would like to note that it is a special day. We are celebrating International Women's Day today, so happy International Women's Day. I would say that we are doing our best to celebrate women on this podcast. You are our fourth guest, and we've had 3 women, so I think we're on the right track.
That's a pretty good ratio, right there.
I hope so. We're doing our part, and we want to continue that too. We are committed to equity and diversity in all of our discussions. So there's so much to talk about with you. I have seen a lot of your work. You've testified very recently on the Hill. You've had some very interesting events, so there's a lot of ground to cover. But I think we should just start with how you see the regulatory environment working with cryptocurrency. I think let's just start broad, and then we can dig into a little more detail as we go from there.
I can give the simple answer, which is I don't see the regulatory environment working very well for crypto at all right now. And as we've gotten deeper into 2023, it never worked well before. And I think we're starting to see degrading in how well it's working as the SEC has increased enforcement actions, as the bank regulators have come out with guidance and warnings about bank access for crypto companies. We're seeing a real degradation in what was already a pretty tenuous situation. My colleague Jack Soloway and I had a piece out 2 days ago in Cointelegraph where we compared Gary Gensler to Michael Corleone, talked about how it looks kind of like the SEC, and you could say the bank regulators as well are looking to snuff out crypto as they're moving through. And I don't think it's too much of a stretch to get to that type of analogy, that type of metaphor, because what we're seeing is a real catch-22 in the regulatory space where the regulators are saying crypto can't operate unless crypto comes under the regulatory umbrella. But there's no good way for crypto to come under the regulatory umbrella. I mean, the SEC in particular, after the Kraken settlement, when Gensler said, well, all you have to do is just fill out a form on the website in order to register. That was insulting. And it's insulting to anyone in the securities space. It's insulting to public companies who spent millions of dollars registering their securities. And it's insulting to crypto companies who have tried and have not really gotten feedback from the SEC or have themselves become subject to enforcement actions for engaging in that type of dialogue with the agency. So I think the regulatory environment's pretty rough right now.
To say that you just come in and fill out a form on a website to be a regulated entity, it seems to be very disingenuous.
Yes, and even if that form was relevant or made sense for most crypto companies, it's not the case that all you do is just fill out a form on the website. I think it's an insult to every public company or every other entrepreneur who's tried to raise capital and knows that it is simply not that easy.
Are there regulators that you think understand how this should be done, or are there regulators that you look up to that think maybe these people or these individuals are on the right track and how they're looking at this space?
No, I think it's difficult to say because what we hear it tends to be from the tops of the individual agencies. And based on what we've seen over the past year, I don't get a sense that there's any particular regulator that has a real grasp. There are people at the regulators that do. I think that there are individuals who have been working on these issues that probably do have a very good grasp of the issues, but the political appointees at the top have not been as in deep as in the issues, or they're motivated by political concerns or other concerns that lead them not to be open to understanding. And I think that's difficult. If you would have asked me 6 months ago, I think I probably would have given the pat answer that the CFTC is a little bit more on top of things. And I do think that the CFTC has had a longer track record with sitting down and trying to understand these issues. They were in early, they thought hard about the questions, they were very much in favor of kind of this innovation space. But as we've gotten deeper into kind of the jurisdictional fight between the SEC and the CFTC, it's not clear to me that it's being motivated by the same interest in innovation or interest in getting it right as it is an interest in making sure that they have as much jurisdiction as possible as well.
It's very concerning, but you also, in a way, have to empathize with the regulators because everything that they're dealing with to regulate is around centralized entities, right? Isn't it that's their model? That's what all the regulations are written to do. And now something comes along that's completely different. How do we address this? What's the path forward?
I think it's a tough question, and I agree we should empathize, not emphasize. We could emphasize it too. Empathize with the regulators because this is difficult. Financial regulation in the U.S. is based off of regulation of intermediaries. A lot of crypto doesn't have that same intermediary concept. And that's where Congress should really be stepping up to give more guidance to the regulators about tackling these new issues. The regulators have their sets of statutes. Most of them were written in the 30s or the 70s if you're lucky. But long before these concepts of decentralization, long before the technology that we're even talking about. And that's not to say that old rules can't be applied to new technology, because I think we see all the time that you can take an older rule and take the spirit of that rule and figure out how it applies. But that's not easy to do with the Securities Acts from 1933 and 1934. And I think we need legislation in this space. Congress is working on that, although I'm not optimistic that it's going to be quick in coming. Although apparently there was a poll a couple of days ago that polled staffers from key committees where there was a lot of optimism, bipartisan optimism among key staffers that there would be some crypto legislation coming in 2023. I think that's a good sign. I'm not sure that I share that level of optimism.
I think we have a relatively short window of time here before the next presidential election is the focus of everyone's attention, and then things are going to grind to a halt for a while before we see any more activity, I would imagine.
Yeah, I think that's how it'll go. I think 2023 and early in 2023, as the cycles go, is probably when something needs to get some momentum building. This week, the House Financial Services Committee's new digital assets subcommittee is going to hold its first hearing. I think that's a sign of the House getting down to business on these issues. And the House had a number of legislative proposals before. The legislative proposals that are associated with that committee hearing right now are pretty narrow. They're fixing the Broker Act, the broker definition, and then the IRS regs. But I think that when they sit down to do some work there, we're likely to see more legislation coming out of the House. And I think, at least initially, the House is going to be where the action is at versus the Senate.
This hearing that's coming up later this week, I think the title of it is quite intriguing. It talks about, I don't recall the exact title, but it's something like attack from the regulators. Is it coincidence or not?
Yeah, coordination or coincidence. They're working on their alliteration.
I see. Yeah. Well, does that seem fair to you, a fair question to ask? Because it seems like a lot of people in the crypto industry feel like it has been an attack as of late.
I think it's a fair question to ask. I think it has to be asked in perspective, though. The banking regulators, at least, have been pretty upfront about the fact that they are coordinating and that they're working together on risks. We hear a lot of, this is Operation Choke Point 2.0, this is obviously illegal, we're trying to keep crypto out of the banking industry. And those are fair questions to ask, but I don't think we have enough evidence at this point to have the conclusion that this is, in fact, a Choke Point 2.0 situation. Because you have to keep in mind, 2022 was a pretty miserable year for crypto risks. And ending 2022 with the FTX debacle, it's not an unreasonable response in some respects for banking regulators to sit down and think about what those risks look like for regulated banks and how banks should be dealing with them. There's a fine line between risk management and trying to keep an industry out of the banking system. And I don't know that we have the data and evidence yet to know which side this is falling on. Maybe the hearing will shed some light on that.
One of the things you mentioned a little earlier was looking at the SEC and how they're trying to navigate this industry and regulate the industry. I'd love to dig into that a little bit more because there's a number of things that have happened at the SEC that I think you've maybe written about or you've talked about. And the fundamental question there is, what is the SEC's role to regulate the industry? Because the SEC is a securities regulator by definition in the name. So that means that you have to have securities to regulate, right? Can you explore that a little bit with me?
Sure. And I think for me, that's one of the million-dollar questions and one that I wish Congress would weigh in on. I'm even less optimistic that Congress is going to tackle that question because it's a difficult one. At Cato, we've put out a paper suggesting a path forward for how to define the difference between a security and a commodity for the SEC's jurisdiction. And that rests on the key question of decentralization, because the SEC and securities law generally grew up as a means of mitigating information asymmetries that happened because kind of the managerial body who was issuing the securities had access to information that investors didn't. That's all well and good if you have a managerial body in the middle. And assuming that the other kind of check boxes for securities are met, you're trying to raise money, there's a commonality of interests, other things. Assuming that those other check boxes are met, if there is a managerial body involved, it might very well be appropriate to regulate it as a security. But where you have a decentralized project where no one has better information than the investor or the user, or where the No one is making any promises to the end user about how this project's going to grow or be successful. There's not a lot of reason to have securities regulation in that space. It's a long way of saying that this all turns on decentralization for us and for me. I think what's important in that space is also kind of the proposal that Commissioner Hester Peirce put forward that takes into account how we deal with projects that are intended to ultimately be decentralized, but are not yet decentralized. And we've proposed, much like she did, kind of a light touch disclosure system that's specific to crypto, that gives information to investors or end users that might be useful. So as opposed to information about everything that shows up in a 10K right now, information about tokenomics or the design of the system, and allows that type of light touch disclosure to serve as the securities law disclosure for products that are going to be on the path towards decentralization.
Right. So if you are a new project and you know that there may be some question about the decentralization of the project, you would go down a path like that would eventually lead you to a place where you would not be a regulated entity under the securities laws, right?
Right. And if you continue to make promises to your users that keep you at the center of that project, you're not going to make it to decentralization. And I think it's fair to be regulated as a security in those circumstances. But we should have a path that allows projects to avoid some of the heavy costs of the securities laws that don't make sense for crypto projects.
Very recently, Chairman Gensler raised questions even about the ability of Bitcoin to be outside of the securities regulatory framework. I don't know how to deal with that.
No, and his position has just continued to seem out of left field. I think I can boil down his position at this point to be there is no such thing as decentralization. And it's difficult to see what's motivating that. His explanations are, well, every project's got a website, and someone made that website, so that website means that someone should be responsible, and it's a security. Not a terribly convincing securities law argument, and it's not any more convincing than his initial argument in the space was anytime someone's looking to make money, it's a security. It's also not securities law. Sometimes I forgive him because he's not a lawyer, and maybe he doesn't know all the details of the law, but at this point, I'm not forgiving him anymore.
I think he's been in very high-level regulatory positions long enough he should get an honorary degree from someplace. I don't think that would be too much of a problem.
Yeah. But the idea that there is no such thing as decentralization doesn't comport with reality. And I think there are very legitimate questions about how you define decentralization and what are the hallmarks of decentralization. But to say that it simply does not exist it's not a serious position.
You referred to Commissioner Peirce's proposal for having some pathway for projects to move from a new project that is possibly centralized to something that is decentralized. They go through like a morphing, as it were. So, first of all, that's pretty amazing to think that a project's going to morph and that you're going to go from one phase to another in terms of regulatory framework. That's kind of a different thing. I don't know that I've seen anything like that before. But we actually had one organization that came out not too long ago saying that they felt that they had effectively morphed. I believe it was Polkadot and the DOT token. Did you take anything from that you thought was interesting that you could comment on?
Well, I thought it was interesting that they were willing to come out and say that they had morphed, because the SEC has not said so. And I think that is kind of the I don't want to say catch-22 again, but that's the dangerous situation that all of these projects are in right now. Because you have a chair of the SEC who does not believe that if someone existed to say that the project had morphed, it obviously had not morphed because someone said the project morphed. And there is no clear pathway. I mean, we're dealing with the 2018 guidance, I think, that was 35 pages long about what does and does not constitute a security. That's the best we've got out of the SEC at the moment. 35 pages of factors that may or may not be applicable. It's not a clear test by any stretch of the imagination. I worried a little bit when Polkadot did that they were putting a giant target on their backs, particularly given the way that the SEC has been operating, where companies and projects that kind of stick their heads up
Right.
tend to be the ones that have found themselves the subject of inquiries. At the same time, it was a pretty brave move on that project's part to set out kind of the pathway that says, look, we were here and we did have a centralized project that we think probably, could have been subject to the securities laws. But now here's how our project operates, and we think we're past that. Brave move. I think time will tell if it was the right move as to whether or not the SEC is going to follow up with an awful lot of questions about that. Which is why I think it's super important to have an actual framework put into place and actual definitions in place so that entrepreneurs and developers feel comfortable saying, no, we met this definition. We will argue it because the definition is clear. We can make our case, and we should be able to win that case when the circumstances are correct.
It's an amazing irony about being able to say you've gone through a morphing, but you can't say you've gone through a morphing because then maybe you didn't morph.
Yeah, which I think is a big part of the problem with Gensler's position on these things, that you could never, as long as there is any communication from anyone at all, in his view, there is no possibility that it's a decentralized project. I mean, you've said before that if a project has lawyers, if someone has hired a lawyer, project's not decentralized because someone had to hire the lawyer. Again, I don't think that's a realistic position when you take a look at kind of the facts on the ground with respect to how these projects can operate.
Jennifer, just I think a week ago or two, Cato had an event on the BSA, the Bank Secrecy Act of 1970. You were there on the panel. You had some great remarks I thought were really informative. Would you like to tell us a little bit about that, but also maybe just start with the BSA, what it is, and in 1970, why was it adopted? Give us some historical context around this.
So the Bank Secrecy Act, if you're not familiar with it already, is a kind of sweeping set of requirements on financial institutions. And financial institutions can be banks, broker-dealers, car dealerships, casinos, Western Union, and crypto companies. That requires them to keep records of the transactions that their customers make and surveil those transactions for evidence of illicit activity. And where a financial institution finds evidence of illicit activity, they need to report it to the government. So there's a lot of tentacles of the BSA. But let me kind of start at the beginning in 1970, because the BSA in 1970 was a lot smaller than the BSA in 2023. Initially, the BSA was put into place in 1970 in order to prevent Americans from evading tax laws by using foreign bank accounts. Pretty narrow topic. And the way it did that was, it required record keeping of transactions. But the primary way that it did that was by requiring all of these financial institutions to file a form called the Currency Transaction Report when transactions were done of more than $10,000 in cash. So if you went to your bank and withdrew $10,000, your bank had to tell the federal government, because there was a real fear that you were taking that $10,000 to Switzerland and you were never going to pay taxes on it. over time, the Bank Secrecy Act has been added to substantially. In the 1980s, it was looked at as a tool to fight the war on drugs. And in the early 90s, we added to the Bank Secrecy Act what are known as suspicious activity reports, which are kind of the true surveillance portion of the Bank Secrecy Act, where banks and other financial institutions need to take a look at their customers' transactions and file a SAR, a suspicious activity report, whenever they suspect their customers of engaging in illegal activity. And illegal activity means an awful lot of things. It means money laundering. Now it means terrorist financing. But it also could mean tax evasion. It could mean child trafficking. Basically anything that is illegal is part of this requirement. And it's the case that there are millions of reports filed under the Bank Secrecy Act every year. In 2019, which was the last year that I saw figures for, but there might be newer figures than that, there were 20 million reports filed. And only a small percentage of those reports are ever looked at. And when you compare the number of reports to the number of money laundering investigations, you don't really see that 20 million reports are leading to a large number of money laundering investigations. So you set aside kind of the obvious difficulties with financial privacy, with government surveillance, with the Fourth Amendment, which I'm sure we're going to talk about. You also have a very real question of what is this doing? What are all of these reports doing? They don't seem to be making anyone any safer. They just seem to be creating a mountain of paperwork that invades people's privacy for very little reason and actually puts burdens on banks and individuals that can keep people out of the banking system. Because either those people are deemed too risky by banks. For example, immigrants that want to send money across borders to states that are, less than stellar in the U.S. government's view in terms of their propensity for illegal activity. And it also keeps people out of the banking system who don't want the government snooping through all of their financial transactions for perfectly legitimate reasons.
It became terrorist financing more recently, but prior to that, there was other justifications. So the justification for this has changed over time.
What's notable is that $10,000 figure hasn't changed since 1970. And in 1970, I saw you could have bought 2 new Corvettes for $10,000. It's not going to get you much in 2023. Adjusted for inflation, $10,000 in 1970 is about $75,000 in today's dollars. So this kind of governmental dragnet brings in so much more information than it ever would have brought in when they initially put the law into place in 1970. So it's expanded by direct congressional action. It's expanded by kind of just letting it roll along and letting the thresholds decline over time. And it's a shadow, or the 1970 Bank Secrecy Act is a shadow of what today's Bank Secrecy Act looks like. And I think it's notable that even the 1970 Bank Secrecy Act raised a lot of questions about whether or not it was consistent with Americans' Fourth Amendment rights, with their First Amendment rights, and with their Fifth Amendment rights as well. And the Supreme Court took up 2 cases in the 70s on the Bank Secrecy Act. One of them was California Bankers Association v. Schulp and United States v. Miller, in case you want to go read some fascinating Supreme Court decisions. And in both of those cases, the majority of the court upheld the Bank Secrecy Act. But it was a slim majority, and the dissenters were pretty adamant. I'll get to the dissenters in a second. But with respect to the Bank Secrecy Act generally, even members of the majority who concurred in the judgment said, this does kind of walk a line, and we'd have real concerns about its constitutionality if it expanded much more from here. Well, it's expanded an awful lot more since the 1970s. So I think it's a very open question what today's Supreme Court would do with it. The dissenters included Justice Thurgood Marshall, who was dissented in both cases, saying that this was an unconstitutional infringement on people's Fourth Amendment rights, that the information contained in bank accounts said a lot about a person, which is also a First Amendment problem, because when the government can take a look into your bank account, they can see who you are, what do you give money to, what causes do you support. Could piece together an awful lot about a person's views, expressions, and other things by looking at how they spend their money. And, as you noted, in the 1970s, we used cash for a lot more things. So a bank account in the 1970s didn't give nearly as close to a full picture about how someone's life ran in 1974 as it does in 2023.
That's right. And it's mind-boggling to me that legislation would have passed when we know that it is the government's objective, the Federal Reserve's objective, to have a certain level of inflation. We know that our money is going to be worth less in the future, but yet $10,000 was selected as the amount to report on, and that never has changed. How is that possible?
It's amazing. It is unfortunately not unusual with respect to any sort of level legislation that gets put into place. It oftentimes seems like Congress just forgets to index things to inflation. I don't understand how it keeps happening, but it's not unusual. And we've had kind of discussions, you've seen discussions on the Hill back and forth over the years about going back to fix those numbers. For Security transaction report, it's $10,000. For SARS, the numbers vary, but it's $3,000 if you're a Muncie transmission business, or $5,000 if you're a bank. These are all very low numbers, and the fact that they are such low numbers is one of the major contributing factors to why so many reports are filed. Unfortunately, none of those efforts have been successful to date. I think maybe we'll see some more efforts in 2023 because they kind of seem to be a perennial issue. Hopefully it'll get more traction at this point, because it's really in everyone's best interest that if we're going to have something like the Bank Secrecy Act, and I don't think we should have something like the Bank Secrecy Act at all, because any of this surveillance is problematic from a Fourth Amendment standpoint. But if we're going to make the choice to have the Bank Secrecy Act, it doesn't make a lot of sense to just throw a whole bunch of useless information at law enforcement, who then has to spend their time digging through a haystack for the needle. We should at least do law enforcement the favor of making sure that the haystack's a little bit smaller and a little bit more targeted.
Right. Ironically, we're making their job even more difficult by
Yes.
throwing so much data at them.
Yep.
And before long, $10,000 in 1970 is going to be like a $10 bill. So
Yep.
they're going to have a whole lot of information. I thought it was interesting you said you don't think we should have the BSA at all. So that's a really important statement, I think. And it does get to this issue of what is the appropriate role of government and the kind of surveillance that government should be involved in with regard to watching what people do with their financial transactions and capturing all of that data. In a perfect world, let's say we don't have the BSA, what are good ways for policymakers to think about addressing these issues that are different than the BSA?
Yeah, well, I think I start from the position that the Fourth Amendment has already figured this out for us. We've had the Fourth Amendment, which sets the balance between the government's need for information to fight crime and an individual citizen's rights to privacy. And the government can get information to fight crime. They just have to get a warrant. They need to prove that they have the right level of need for that information. So on the Bank Secrecy Act kind of financial privacy point, we've proposed, and I've proposed, and I think this would be the way to go, is the banks should be required to keep records, but the government doesn't get a hold of those records unless they make the proper showing to get a warrant. You don't have fishing expeditions, you don't have the surveillance that's happening, but where there's a real concern about illegal activity, the government can still investigate. So that's, I say, the kind of basic balance that the Constitution has already struck. And I think it's also the case when we think about whether we need something like the BSA, we tend to just assume that if you got rid of the government surveillance in this space, it would be field day for criminals. Every bank would say, please, 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 come bank with us. We love criminals. And that's simply not going to be the case. Prior to the BSA and in a world without the BSA, there are still very real risks that are to financial institutions for dealing with criminals. Not only the legal risks of aiding and abetting or co-conspiratorship in some circumstances with respect to their clients, but also the reputational risks. Most banks are not going to want to be the bank that's known as the terrorist bank, and are going to continue themselves to keep an eye on their customers to make sure that their customers are not financing terrorism on the side. And to the extent that you have a bank that wants to be the terrorist bank, pretty sure that law enforcement's going to figure that out pretty quickly.
Might actually make the investigations a little easier.
It may very well do so. So in a world without this surveillance, we're not without tools to fight crime. Law enforcement can still do their jobs through getting a warrant, and private entities will still have an interest in ensuring that their customers are operating within some bounds of the law.
I think that's a great observation, that it's not in anyone's interest to do business with criminals. I think that should be very intuitive to everyone. I certainly don't want to do business with criminals. And if you do, any entity, it would be at great risk, even personal risk from doing that kind of business.
Yeah, so it's not like everyone is just going to be, say, Bad Guy Inc. is going to go wild if there is no ongoing surveillance. And it's also the case that now, even with all of this ongoing surveillance, crime happens through banks. Crime happens through non-banks. So the right balance in looking at whether something like the BSA is successful or needed is not zero crime. We're not trying to get down to no crime at all. And that shouldn't be the comparator for deciding whether or not we need something like the BSA.
And just to be clear, BSA, Bank Secrecy Act, people might think, oh, this is only banks. We're here talking about crypto policy. But I think that the BSA extends far beyond banks, right? Like, this does affect the crypto policy environment, right?
Yes, it absolutely does. And it raises a whole host of difficult questions in the crypto policy environment, kind of long term. So short term, and even not so short term, crypto exchanges and other crypto businesses have been subject to the BSA for a number of years. They have to engage in the same types of checks on their customers to make sure their customers are who they say they are. They need to engage in the same type of surveillance for suspicious activity reporting. And they're subject to the same rules as money service businesses under the crypto or under the Bank Secrecy Act rules and the anti-money laundering rules. We've heard over time that applies regardless of whether you are a centralized crypto entity or a DeFi protocol. That obviously raises a lot of questions as to how does a DeFi protocol comply with these types of requirements. And I think there's DeFi protocols that don't try. I think there's DeFi protocols that try. And there's a decent amount of variation in how that's being dealt with in the industry right now. But we're also hearing on Capitol Hill, it's been the case that the Bank Secrecy Act just continues to expand. There was another expansion in 2020 that kind of took the regulatory requirements for crypto and enshrined it into legislation to make clear that crypto truly is covered by the Bank Secrecy Act. But we've recently heard Elizabeth Warren and Roger Marshall in the Senate have proposed a further expansion of the Bank Secrecy Act in the crypto space, with Elizabeth Warren's usual talking point that crypto is just for crime, which we all know is not true. But that proposal would seek to expand AML requirements to self-hosted wallets and other crypto circumstances that are much more like using cash than running your money through an exchange or a bank. It's a dramatically different way to think about the Bank Secrecy Act, and it's a very dangerous way to think about the Bank Secrecy Act, to apply it to crypto in that way. It's a dangerous way to think about it because it's a pretty short hop to doing the same thing to cash as well. That type of expansion is, say, really, really terrible.
I'm glad you brought up the Warren and Marshall bill. I know that a lot of people have talked about that. It's been covered by the Blockchain Association and others. And it effectively makes the whole industry illegal, right? Isn't that there's no way that the industry could comply with those types of regulations?
Yeah, exactly. It would basically tamp down everything. And I would say it puts unwarranted intrusion onto individuals. We've always had a zone of privacy in this country where you were able to use cash without the government being able to track it individually. Crypto on a peer-to-peer transaction basis is essentially digital cash in that way. And say having individuals responsible for their own AML obligations is basically impossible. And it really, say, takes away the benefits of being able to engage in peer-to-peer decentralized transactions.
Jennifer, on the BSA, you mentioned that banks are collecting all of this information, and this has been challenged, and now we have legal doctrine around it. What is that legal doctrine, and how is that continuing to stay in place over time?
Sure. So that's known as the third-party doctrine, and it was put into place in the 1970s. One of the cases was United States v. Miller, which was the Bank Secrecy Act case. And that doctrine says that if you give your information to a third party, like a bank, you lose your expectation of privacy over it. So the Fourth Amendment doesn't apply. That's obviously a giant carve-out from the Fourth Amendment that's only gotten bigger in the decades that have followed, as we are constantly giving information to third parties in order to just run our lives normally. The third-party doctrine applies not just in banking situations, but your cell phone carrier, your credit card company. I assume your security camera in your home now, your Ring camera. The third-party doctrine is exceedingly broad when we run most of our lives through intermediaries in some form or another. And the Supreme Court has started to question whether something like the third-party doctrine is consistent with modern life. We've seen a couple of cases in the past decade where the court has, maybe the court upheld part of it, but there were dissents by two justices who you don't tend to think agree with each other, Justice Sotomayor and Justice Gorsuch, who have both raised serious questions about whether the third-party doctrine is compatible with the Fourth Amendment in modern life. I think that's a nice opening for action in this space to revisit a doctrine that had some, say, questionable origins in the first place, but really doesn't make a lot of sense to say in 2023 that if any third party is involved with your information, you don't expect that information to remain confidential or private, and the government has every right to it. Basically strips most of us of most of our privacy at all times.
Is there any chance that we'll see more challenges coming? Like, I would think that this would be so ripe for the court to review again.
Yeah, I think we'll see more challenges coming, but probably mostly in other technologies versus the Bank Secrecy Act challenges directly. I wish we'd see a Bank Secrecy Act challenge directly, but there's a couple of hurdles to that, one of which is just the fact that the Supreme Court decisions in the 70s were so on point, and district courts have to follow Supreme Court precedent. And unless you have a very well-funded plaintiff who's able to take it all the way up to the Supreme Court to get the Supreme Court to change their mind, it's not going to go anywhere. It's also the case with respect to suspicious activity reports in particular that you or I or anyone else don't know when those have been filed on us. In fact, it's illegal for you to know. They have to be kept confidential. So if a suspicious activity report were to be filed on me, I can't make a legal challenge about it because I don't know that it was filed, which is another hurdle in that space. But I think that we'll continue to see cases that raise third-party doctrine questions with respect to other types of technology, security camera footage, cell phones. There have been cases in the past over, heat detection with drones. And I think that we'll see cases where there are more novel technologies that can present opportunities for the court to revisit the doctrine. And if the court revisits the doctrine wholesale, then the Bank Secrecy Act comes up for question.
Outside of the Bank Secrecy Act, other than the Bank Secrecy Act, there are other ways that government is collecting a lot of very important personal information, financial information. I understand you have been talking about a consolidated database that the SEC is building or is going to go into place very imminently. And I suspect that maybe we could talk a little bit about what the IRS might be doing as well. Do you want to dive into those areas a little bit and talk about other ways that our financial privacy is being threatened?
Sure. I would say the SEC, which is where I'll start, I don't think that this issue has been getting nearly enough attention. And it's an issue that's kind of been in play for the past more than a decade at this point, which is the SEC's Consolidated Audit Trail, also known as the CAT. And perhaps I will make cat puns. Maybe I will not make cat puns if I can control myself. But the CAT is kind of this exceedingly large database that is meant to collect all trading information that is done in the United States. Think about that for a minute. That is an exceedingly large amount of information. Some have said this might even be the largest database in the world. And the SEC's view was that they needed this to be put together because way back in 2010, if you remember, there was a flash crash in 2010 when stock prices dramatically dropped, and the SEC couldn't figure out what happened. In part because they couldn't piece together market data, they weren't sure what had happened, and the idea was, well, if we had better data that allowed us to see every single trade, every single execution, every single order, every single cancellation, everything, we would have been able to look at that and know instantly why that had happened. Well, that got approved in 2012, and they've spent the next 10 years putting together that database. A database by itself is a problem because it basically shows all of an individual's activity in the stock market, which is expressive activity. People's trades can show their, beliefs about what companies are going to do well. I think we know these days, particularly in the time of ESG, people's trades can show their political views or their views about climate change or any number of things. It's a rich pot of expressive data. But not only does this database have the trades themselves, the SEC is requiring that information in the database have customer information so that the SEC can link up individual customers to the trading. Initially, the SEC had wanted to have names, social security numbers, date of birth, basically everyone's easily documentable personal identifying information in the database. They cut back some of that, but now it's names, addresses, and year of birth, as if that makes it impossible to figure out who a person is. I think it's pretty obvious that that is also personally identifying information. And the SEC has said time and again, no, we're just going to use this to look for, trading violations. But again, it's a massive surveillance database that raises the same First and Fourth Amendment concerns that something like the Bank Secrecy Act does, where there's a general assumption that the government is entitled to this information regardless of whether you've done anything wrong. And that's not an assumption that the Constitution supports. The Constitution doesn't allow the government to collect this information to make their haystack bigger so that they can maybe find a needle at the bottom of it. Again, and that's also to say the SEC has had plenty of opportunities and plenty of ways to catch people who were violating the securities laws by trading prior to this. It was always the case that there were reported trades, and if the SEC wanted to find out who made those trades, the SEC would go back to the broker-dealer and ask, hey, who made that trade? But that's much more similar to a warrant process, where they've identified some questionable behavior, they've met the standard, and now they're looking for someone to talk to about it. Very different from just collecting all of the information up front and taking a look through. And that's to set aside all the data privacy concerns and other concerns with having the biggest database in the world full of all of this very important trading information. I think it's unquestionable that the SEC, who's been hacked before, will be a target for hacking again. So the CAT is really concerning, and I think because it's technical, it hasn't gotten the level of interest that a lot of these other types of issues have. I would say Commissioner Peirce has been, very vocal in her opposition to the CAT, but largely what we hear are questions about how's the security going to be, as if as long as the government had good data security, this would all be fine. And that's definitely not the case.
Right. Yeah. Shocking. And you said this is imminent, right? This is going into place very soon.
This is imminent. So the SEC has already been collecting the trading data kind of in waves since 2020. The system came online in 2020, collecting the trading data. And over time, it's been collecting more data from different trading entities. But in March, mid-March, I think actually on St. Patrick's Day, the part of the database that will collect the customer information is going live. So up till this point, the SEC is only getting the trading information, and they still need to go back and ask the brokers, hey, who's doing these trades? That won't be the case anymore after the middle of this month.
Is FINRA involved in that, your prior employer?
FINRA is involved in that. There's kind of been a long saga with the CAT. FINRA is, a portion of FINRA is the CAT administrator at this point, but that it is all worked together with FINRA and the other self-regulatory organizations, so NYSE, NASDAQ, and others, are all part of the groups that are responsible for this. It also goes to show that when we talk about the CAT, we often talk about just the SEC, thinking that this data is just going to be available to the SEC. That's also not the case. The data in the CAT will be available to all of the SROs, including FINRA. So rather than just having the SEC have a surveillance window, that surveillance window is going to be accessible to thousands of people throughout a number of organizations.
There have been calls for having a self-regulatory organization for crypto. And as you mentioned the CAT and how that FINRA and the other trading entities have been having a major role in that, it makes me very nervous because I would like to think that an SRO in the crypto space would help us work through issues. But I see this example and it makes me think that maybe an SRO is going to be directed by the agencies to take certain actions that are maybe not in the industry's best interest and not in even consumers' best interest.
Yeah, I think the idea of an SRO is an interesting one, but I think it's very important to note that, well, there's a couple of different things when we talk about an SRO. I've talked to folks in the crypto space that have said an SRO, but not an SRO like FINRA. I don't really know what that means. What I've been told is, we'd have an SRO, but it wouldn't be subject to government regulation. Well, okay.
It's not an SRO.
That's not an SRO. That's a trade group. That's a group that's going to do internal or private regulatory group, any number of organizations that do that. But that's not an SRO. The SROs are subject to, in this space, the SEC's regulation. And the SROs sit in a very weird place where they are not the government, but they are the government. And at least with the FINRA experience, I think that a lot of broker-dealers don't find the FINRA experience to be a particularly friendly experience to their industry. It's helpful in that you have a dedicated broker-dealer regulator who can just focus on broker-dealer issues. But you have an SRO that needs to kind of justify its place in this world, which doesn't necessarily lead to industry-friendly outcomes. So the idea that a crypto SRO is going to be ultimately a industry-friendly regulator, I think is not necessarily the outcome that's a given. And I think it's a pretty dangerous assumption to make, given the experiences of all of the other financial SROs.
Well, the SRO doesn't fix a broken regulatory regime. If you have a broken regulatory regime and then you bring an SRO on it, you're just more broken, right?
Right. And I think you have a major problem in the crypto space with defining who would be subject to that SRO. I know we like to kind of say crypto, which is this broad category. But what does that mean when you're defining who is subject to the SRO versus who's subject to direct regulation by the SEC? Is just using crypto technology enough? Does it have to be a digital asset? Does it mean that the crypto SRO is also going to look at non-securities NFTs? There's a lot of questions that go into how you even draw the fence around what would be subject to that SRO that I think raise real questions where, particularly further down the line, where you have more integration between the existing financial system and the crypto financial system. So I think the SRO concept sounds great in theory. I think it's difficult in practice.
And just to be clear, when you start an SRO and you become an SRO, that is a very special process, right? It's not like you just would stand up a trade association and then call yourself an SRO. You want to explore that a little bit or just explain that a little bit? Because I think some people in the crypto ecosystem think, why don't we have an SRO? Let's just make an SRO. We'd fix all of our problems.
Yeah, it's not simply that you can create an SRO and go to the SEC and say, we're an SRO.
We're here to help.
Recognize us. Yeah, we're here to help. It depends exactly on where it falls, whether or not there would need to be legislation that would allow it to exist in the first place, because it's an SRO that may very well look different from the broker-dealer SROs or the exchange SROs. So from the get-go, you may very well need a legislative fix in order to allow a crypto SRO to exist. But even if you don't, the SRO's existence is essentially at the whim of the SEC. The SEC would have to approve it. The SEC is going to have to approve basically everything about the way it is set up, the way it would operate, all of the rules for that SRO that are going to govern the SRO's membership have to be approved by the SEC. So in many ways, you're just creating with an SRO another branch of the SEC. And the hope is that that branch of the SEC is going to know the industry better and treat the industry better because it's part of the industry. That hasn't always been the case, as I've said, but it's not simply a matter of, we've created an SRO, now the SEC is going to let us regulate ourselves.
We touched on IRS a little bit. I understand that we're expecting some new regs coming out of the IRS soon that are going to apply directly to crypto. I haven't seen anything in particular, but the rumors are circulating. Do you have any insight into that? But in more a broad perspective, do you have any thoughts about how the IRS is doing things similar to maybe what is happening with the CAT database or with other things collecting information and trying to surveil the markets?
Yeah, so the IRS regs on the broker definition as it applies to crypto, the IRS kicked the can a little bit and said that they weren't going to come out as soon as they thought they were going to. So there's been a little bit of time bought on that. That doesn't mean that I think that the IRS is going to come out with a workable definition of what broker means. That just means that they're going to take a little bit longer to do it. Where I am optimistic on that front is that gives members of Congress some time to get a legislative fix in place. And I'm optimistic about that legislative fix because it was kind of widely recognized on both sides of the aisle when those provisions went into place that the legislation on it wasn't very good. It didn't make a lot of sense, and the legislation was broader than even the Treasury Department intended it to be. We've seen already, I think just this week, Patrick McHenry in the House, along with Richie Torres, so a bipartisan coalition on House Financial Services, and a couple of other members introduced a bill looking to fix the IRS broker definition. And I would expect something like that to move relatively quickly to the extent that it can get the support it needs to pass. Hopefully, that means that Congress will fix the law before the IRS has a chance to act. The IRS, on the other hand, continues to do what the IRS thinks it wants to do best, which is get as much information as possible and then sort it out in the wash later, which is the same problem that we're seeing with the financial regulators and with the SEC. And really, I mean, understandably, the government's position on this is the more they know, the better. It's why we have things like the Constitution to prevent that imbalance of power. We had the proposal last year or the year before, time is slipping away at this point, but to allow the IRS to collect information from people's bank accounts down to anything over $600. That got people into an uproar, as it should have, and that was withdrawn. But what we've seen is that the IRS had a very similar provision that went into effect, again, last year or the year before, that requires reporting of any transactions over $600 out of PayPal, Venmo, other places to the IRS. Again, this is all in the name of we want to make sure that people are paying their taxes. And what's interesting about it is it's justified as we want to make sure that the rich people are paying their share. I mean, rich people are not, it's not $600 in Venmo that has anything to do with billionaires cheating on their taxes. It's a pretty thin cover for the IRS's attempts to just expand financial surveillance of Americans' financial lives.
Wow. It seems to be coming from every different direction in government.
Yeah, it's a pretty depressing state of affairs, I think. And I'm saying it's understandable. If you were in the government and you find that you don't know everything to let you do your job perfectly, of course it makes sense to ask, hey, can we get more information? But the answer to that should be, no, I'm sorry, the government has limited powers. And you can't have all of that information because we don't surveil people on the off chance that they're engaging in bad behavior. We require some sort of evidence of bad behavior before we go get that information.
Well, as we talk about all of these concerning things, let's just throw on one more on top that I know you've been looking at, and that is the possibility of the U.S. having a central bank digital currency. And a lot of people are concerned that this could take us into a place of true dystopia. And I'd love to hear your thoughts about that and hopefully give me some good news that we might be able to avoid that.
Well, we'll see about the good news. A central bank digital currency is rife with all of these problems of surveillance. It would allow the government much more access into seeing our daily transactions, and depending on how it's designed, would allow the government direct access to your bank account. Of course, right now, the Fed and proponents of CBDCs say that they're not interested in messing with how you spend your money, but that would open up the ability to do so. So, for example, the government decided that I shouldn't eat that second bag of Cheetos today. It could put a restriction on my account that says no more Cheetos. If I'm not spending money fast enough in order to help the economy grow, it could take money out of my account. It's an exceedingly slippery slope when you allow the government into that type of activity. And whether or not we have good intentions in 2023, there is no promise of good intentions in 2026 or 2040. And the central bank digital currency, I think above all of that, is that it doesn't seem to be solving a problem. We have commercial banks that essentially we have digital currency. In the forms of our debit accounts, in the forms of the ledger lines that are kept in commercial banks. I'm not sure that a central bank digital currency does much for me. What it does do is allows politicians to say, well, China had one and we can't be behind China. I'm not sure that this is something we want to follow China down the path on. China has actually been pretty explicit that they want to be able to use it for their governmental surveillance of their population and control over how their population spends money. That is not something that we should have in the United States. On the minor optimism front on that, we have not seen the Fed, by and large, as excited to go down that path as some politicians have been or as some people in the Treasury have been. The Fed has been very cautious. We continue to hear statements from Jerome Powell about how the Fed would be ready to do this if Congress gave the approval. And there's distinctions to be drawn in the CBDC space between a retail CBDC or a wholesale CBDC. My colleagues, Nick Anthony and Norbert Michel, have done great work in that space with kind of primers about how all of this works. But in general, the Fed is not, I would say not opposed to a CBDC, but not clamoring for it either, which I think can put a little bit of the brakes on the project. We have also seen members of Congress stand up and rather than looking to propose a CBDC, have been interested in prohibiting a CBDC. Congressman Emmer, in particular, has put out a piece of legislation that would ban the Fed from creating a CBDC. And in fact, this week, Cato is going to have an event on CBDCs on Thursday, March 9th, featuring Congressman Emmer, but also featuring a number of my colleagues and others who are going to talk about the dangers that a CBDC poses and why the United States should not go down that path.
Right. I think that clearly following China on things like this doesn't make a lot of sense. I like it when China follows us, when they try to keep up with us on AI and the internet and other things rather than, we should be very cautious.
I do. Well, it kind of reminds me of the Charlie Munger op-ed in the Wall Street Journal about how China did a great job in banning crypto, and we should praise the Chinese Communist Party for having done that. Again, not something that we should be emulating China in, and not quite sure that any of these thought processes are good when we start with, well, China did it first.
On the point that there's not really a problem that needs to be solved, we have the solution even in crypto, right, with a stable coin.
Yep.
And that serves the purpose, does it not?
It does. And having stable coins function at the same time as a CBDC is essentially, probably a death knell for stable coins, if for no other reason than the Fed would be a competitor in the stablecoin space. And competing against the government generally does not win to the private sector. It's not good for the private sector. Not a fair fight at all.
Exactly.
Which is one of the reasons on the stablecoin front that I don't think that the Fed is particularly well suited to be the regulator for stablecoins either. And we haven't really talked much about stablecoins today, but there's legislative proposals about how do we regulate stablecoins. And some of the proposals have said, well, the Fed should do it. The Fed's got a major conflict of interest with respect to regulating something like stablecoins, where the Fed also has a dog in the fight.
Jennifer, we talked about the SEC a lot. We've discussed how the current approach is really regulation by enforcement, and we're hoping that we'll see legislation that will help clarify some of that. In the interim, we have the third branch of government that is, there's things happening there. There's cases that are moving forward, even some that are probably going to come to fruition here in the near future. Do you want to talk about how that dynamic is going to affect what we see on the agency and regulatory front as well as in the congressional front, and how that will perhaps move us forward?
Sure. Litigation is, sometimes the last resort, where if there's no ability to get things clarified at the regulator or clarified in Congress, sometimes the courts are truly the only option. But I think what's important to keep in mind with the courts is it is not a fast process. We're looking now for a possible decision in the Ripple matter within the next couple of months. That matter was filed at the end of 2020. So we are already a couple of years into that process just at the district court level. And that case is out in front and asking questions about when is a token a security. It's an important set of questions, and one that the industry would like an answer to, whether that comes from the SEC or comes from Congress or comes from the courts. That question won't be settled for years in litigation. The district court case will likely be appealed regardless of who wins. And an appellate court decision may very well not be the final word. They may very well need to go all the way to the Supreme Court. So we're talking several more years of litigation just on that one case alone. And we know that the question of security versus commodity is not the only question that the industry is grappling with at the moment. So while litigation can be a good route for getting individual questions answered, those answers don't come quickly. I think the litigation could have some change in the dynamic with respect to the regulator or with respect to Congress. particularly if the regulator changes hands over the course of the next couple of years. I don't think that a loss in any particular case is going to change Gary Gensler's strategy. We haven't seen much of a shift in strategy. He seems pretty committed. I think that losses in any cases in the courts will just cause him to appeal and continue moving forward. But that's not necessarily the case if the agency has different leadership, which could happen with a different presidential administration. It could happen with the continuation of the Biden administration if Gensler no longer wants to be the SEC chair after 2024. So there's open questions there and how litigation might influence the regulators. Congress could also be swayed by litigation outcomes, although I think they're a little bit more... I think the chance that litigation is going to change the view in Congress is more remote because Congress itself is not a litigant. And it's not Congress's job to fight or not fight in the courts. This is kind of my gut feeling on this, is that Congress would be perfectly happy to have the courts just decide the question, because then you don't have to deal with gaining a coalition and writing legislation, regardless of how that comes out. If Congress is not moving now, it's pretty easy for Congress to say, oh, well, the courts can just decide it. Look, they already started. And maybe that won't be the outcome, but my gut feeling is that the litigation wins or losses will have more effect on the regulator level than on kind of coalescing around a path forward in Congress.
Well, that's insightful, and thanks for that observation. A little bit disappointing, though, I have to admit, because I hear more and more people saying that we are going to have to resort to litigation. And as you've just explained, that can take many years, and then even then, it may not give you the resolution that exactly you're looking for.
Yeah. I would say the kind of coded to that is that if the courts ultimately come out with an unworkable solution or a decision that Congress kind of writ large doesn't agree with, at least litigation decisions and decisions by the courts create kind of a clear set of issues for Congress to deal with, rather than the broader set of what do we work on first. So maybe there's a little bit more room for optimism there on giving Congress a bit of a push. If the courts can narrow the issue for Congress, it might be easier to get Congress to focus.
Thanks for giving me some hope. Looking far into the future, do you perceive cryptocurrencies to be that alternative that will be a better system?
That's a tough question because I can't see into the future. I think there's promise there, but I think there's also pitfalls there. And I think that the important thing for regulation right now, as well as for development, is that there shouldn't be any sort of regulatory barriers that are put into place that prevent crypto from developing in whatever way it's going to develop. It may very well be the next form of money. It might be the next form of better money. But even if it doesn't get there, that's not a reason for the government to decide that it needs to be stopped, it needs to be pushed offshore, or that it doesn't have worth. There was, an exchange recently with Senator Lomas, I think it was yesterday, was talking about Bitcoin mining and during a hearing and asking questions about whether or not it's the government's role to decide what's a good use of electricity and what's not. It's obviously not the government's role to make that choice. And just a couple of days ago, Gary Gensler kind of poo-pooed the idea that if crypto went offshore, it's no big deal because he thinks AI is going to be the more transformative technology for the future. Again, it's not the government's decision as to what is going to be more transformative. and choosing to elevate one type of technology over another. We need rules here that allow technologies to develop without the encumbrance and the judgment of the government on top of them.
As if there would only be one technology that would be important.
Yes, and the entire concept is kind of absurd when you think about it. And that there's zero chance that I trust the SEC to see the future on what's going to be good technology in the future. And I think there's a less than zero chance that I trust Congress to pick what the winning technology is going to be going forward. So it's vitally important that we don't throw up roadblocks, particularly based on some regulator or some legislator's view on what they think might be good or might be bad.
For sure. Yeah, and at least with cryptocurrency, we probably don't have to worry about cryptocurrency gaining sentience and then deciding to wipe out all humankind. So
True. So I'm a little skeptical of whatever Gensler's thinking about AI there, but
I'm looking forward to all of the innovation. I want it all to thrive, especially cryptocurrency. Jennifer, you know that financial privacy is very important to what we do, my colleague Gary and I, what we do at the Electric Coin Company. It's all about developing the cryptocurrency Zcash, which has very strong privacy protection features. After listening to everything you've said today, it seems very clear to me that when there is an option to surveil, it's just too enticing for people to go down that path, for government to say, we need that information, let's use this information because it's available and we'll have someone report it. I am very hopeful that a tool like Zcash can be important as not providing that information because it doesn't exist. It's a very special technology with zero-knowledge proofs that eliminates the ability to trace, like you could Bitcoin, for example, just by looking at the blockchain. What are your thoughts about that? Do you think that's a key criteria for what we should be looking for in crypto, to pretty much just eliminate the information so that that's not something that regulators and government go after because it is such a threat to our personal privacy and our liberty?
So I think that eliminating the information helps in terms of stopping the government from being able to get that information. What I think is even more key is kind of doing the work that, say, you've been doing with Zcash and Electric Coin Company, which is educating people about their interests in privacy, so that individuals kind of stand up and say, no, I don't want the government getting that information about me. And it's not because I'm a criminal. It's because privacy is normal. And as an American, as a human being, I have the right to maintain privacy in my personal affairs. And kind of a groundswell of that type of sentiment makes products like privacy coins and others more attractive. And what it also does is shows the government that, well, A, it shouldn't be taking all of that information, period. But that messing with people's privacy by, say, limiting the availability of privacy coins or limiting the availability of software that obscures transmission and other things, as we saw Tornado Cash and others, but that people value that type of privacy and that type of technology that allows them to maintain their privacy, and that the government should tread lightly in that space.
Well, you can be assured that we are going to continue to educate on this point and to advocate for privacy in financial transactions. That's not all that we talk about here on the podcast, but it is definitely a theme that is certainly very important to us and that we try to work in. So thank you. You have given such a great overview of so many different topics today, and especially focused on financial privacy. So I am so thankful for you being here, Jennifer. I look forward to Cato's events and watching your work in the future. And perhaps we can even have you back in the future to talk about this more. So thank you.
Great. Thanks so much for having me on. It was a great time.